This is the Media Police Post from the Forthall School of Government. In this show, we police the state of truth in the Republic. And because truth is communicated to us by journalists and analysts, we have made it our civic duty to put it to the test. We advance from two confirmed truths about the media. One, and in the words of Roger Stone, the media is either lazy or evil. And for the most part, it is both evil and lazy. That is why the truth, their truth, must be put to a test. Two, another confirmed truth is that journalism is verified gossip. In fact, what is presented to us as news analysis is gossip that has been verified by journalists. This gossip has to be ground truthed. We will monitor columnists, we will assess the state of truth and what they submit to the Republic, and we will pass verdict on what is true and what is not. For the record, we are not journalists, we are thinkers, we are not lazy or evil, and we do not verify gossip. What we give you is the truth that sets you free. On today's show, we will discuss either our favorite columns of last week or columns which reflect unformed and uninformed opinions, and columns that made you stupid. These are columns that fell into the cognitive trap of we see things as we are, not as they are, or that are based on conjuncture history, and lastly, ones that smack of envelope journalism. Welcome to JNCS. What are we looking at today?
Mr. William Ruto. And I will refer to him as such because I am now fully convinced that we should no longer continue to recognize him as a title holder of a constitutional office to which he has visited so much ill reputation. This man, who swore the oaths of office and of true allegiance, this man who held a Bible in his right hand and said that he swore fidelity to our country and to President in full realization of the high calling of the office he was about to enter. This man who is now accused of gross violations of the Constitution, who faces the prospect of impeachment, and who repeatedly registered wanton defiance against his principal, the President, Mr. William Ruto has no moral authority to talk to us about constitutionalism. Ladies and gentlemen, if you keep the counsel of someone who suggested that you should eliminate the president, and he was arrogant enough to suggest that through a tweet, and then you invite that man into your inner sanctum of advisors, how can you even utter the word constitutionalism? We haven't even mentioned that fact that Ruto and his Red Army led a nationwide campaign to reject the Constitution in 2010. You are now the defender of the Constitution? But Mr. William is not the only person who is perplexing in his contradictions. On Thursday, the 13th of May 2021, the High Court rendered the BBI judgment, which contained two major findings that contradicted two previous decisions of the High Court. They're contradicting a ruling by Justice Mativo from March last year, which essentially determined that the president was pursuing a noble constitutional requirement, which was to unite the country. Secondly, they disregarded a 2018 decision by Lady Justice Okwanye, in which it was determined that the IEBC was properly constituted based on a reading of Article 250 of the Constitution. Even Chebukati has said he will appeal last Thursday's decision. Now, some people would argue that this is a 5-judge bench on a constitutional matter, so it has more authority. Even then, the fact that you have two judges of the High Court holding completely opposite findings on serious constitutional issues in two recent decisions is sufficient reason to question the soundness of the reasoning and the jurisprudence of the BBI judges. These are not pedestrians arriving at very different decisions. Justice Mativo and Lady Justice Okwanye are peers of the 5 BBI judges. I'd also like to argue that some people who are celebrating this decision are misplacing their passions for two reasons. It is one thing to celebrate the fact that given our history and experiences under previous regimes, we now live in a country where such decisions can be issued by our courts. Once upon a time, they would not have seen the light of day. Secondly, there are people who are celebrating the decision because they disagreed with BBI to begin with. All that is not the same as saying that the jurisprudence and reasoning of the 5 Wikipedia judges is sound. In fact, I would like to draw a distinction between judicial independence and decisional independence. The fact that the executive has not interfered with the judge's decision and has responded through an appeal process, that is respect for judicial independence. However, the fact that 2 of the judges sitting on the matter had their career progression put on hold for security reasons by the same president that they were making rulings on shows that the judges lacked decisional independence. If you are making a decision about the president and you are even saying some of the orders affect him personally, and you even refer to him as Mr. Uhuru Kenyatta, and yet he is the same person who has delayed your promotion to the Court of Appeal, then that is sufficient grounds for recusal. You do not have decisional independence, and that is a completely different thing from judicial independence. Decisional independence is about the personal bias and lack of impartiality of the judges. It is an ancient maxim that justice must not only be done, it must be seen to be done. The perception of bias is sufficient reason for recusal if the court is truly to be a temple of justice.
Oh yes, so true. And I think I'll just carry on with what CS just mentioned. And I want to urge the public to separate the issues before us. That is, the BBI process and the actions of the judiciary. To start, just as CS said, there's nothing wrong with disagreeing with the BBI bill, to each their own. But we need to look at the High Court's ruling as a separate issue that has the potential to affect the country in ways that we do not understand right now. So I have only one issue I wish to address, and that is judicial activism. I start with judicial activism because I want to accuse the Kenyan courts of misunderstanding their role in government. Judicial activism is defined as a philosophy of judicial decision-making whereby judges allow their personal views about public policy to guide their decisions. Simply put, it's the courts deciding to make policy instead of interpret law. And in my view, we must blast those judges for overstepping their bounds and placing their own agendas before country. Take Justice Odunga, for example. This man already had a rocky reputation for making extreme decisions of a constitutional and executive nature. He is known for having his judgments overruled, and he is known for using the power of the courts to undo the work of the executive. In fact, in his very own words, he said, "This may be construed to mean judicial activism, but the law has to be developed." And this is where things have gone wrong. Remember, judicial activism is about letting your views guide your decisions. And here, Odunga may be more dangerous than Maraga because he's actually quite intelligent. But like Maraga, Odunga is a legal maniac. Both believe it is their right to follow the letter of the law to the end, no ifs, ands, or buts. But this is a slippery slope. I'll repeat again what Odunga said. This may be construed to mean judicial activism, but the law has to be developed. Now, I don't know what book he's reading from, but nowhere is it stated that the role of the courts is to develop the law. That is the function of Parliament as a representative of the people. The courts exist to apply and administer the law. End of story. So what this looks like is a rogue judiciary that is convinced that fidelity to the law comes before those who have been elected, but also comes before the people themselves. In other words, the judiciary has become a law unto itself. And to me, this will be opening a Pandora's box that strips the people of their constitutionally given rights and puts the courts at the forefront of decision making. The problem with judicial activism that we continue to witness in Kenya is that it usurps the power of elected branches of government, which in the long run damages the rule of law and democracy. Dear Kenyans, I want to remind you that of the 3 arms of government, only the executive and the legislative branches have true legitimacy. What I mean here is that Parliament and the executive were elected directly by you and me. The judiciary, on the other hand, only has extended legitimacy because their authority is conferred through our elected officials. I will end with the thoughts of another radical judge from 1800 in America, Chief Justice John Marshall was of the belief that the people surrender their authority to the courts, and that, although the people were the ultimate sovereign, in consenting to be governed, they had chosen a particular form of governmental control.
Yeah.
This is how judicial activism was born. And it ought to frighten the public, because I know it frightens me.
Yeah, good stuff there. So last week's ruling should be a cause for concern, like both of these guys have said, for both sides of the political divide as well. And yes, we live in a polarized era in which mutual suspicions and animosities increasingly define our politics. In such a period, constitutional law can take two forms. It can be a continuation of political conflict by other means, or a search for neutral principles that may be mutually reinforcing across the nation's political divides. The ruling last week was prickly because it showed just how far we are from being a constitutional government. The ruling failed to use the Constitution as a framework to facilitate and indeed constitute ordinary popular politics. That the judiciary is a referee between the executive and the legislature is truly insincere in this case. The judges have the discretion to change the strike zone and use that discretion to advance their own biases and preferences. For example, on the IEBC matter, the judges erred in elevating statutory provisions of the IEBC Act above constitutional provisions. The Constitution sets the quorum of the Commission members at 3. While the IEBC Act says a quorum should be 5 so that it can conduct any business. So I'll leave that to you. But revisiting aside, the judiciary should use the doctrine of symmetric constitutionalism, a method judges use when deciding hard cases. That is, when judges have doctrinal discretion in deciding difficult constitutional issues, they should work to find a doctrinal path or a rationale for a decision that gives something to both sides, something they can both work with. When possible, the courts should lean towards outcomes or doctrines and rationales that give valuable protections across both sides of the nation's major political divides. By the same token, they should disfavor understandings that frame constitutional law as a matter of zero-sum competition between these competing partisan visions. So what's the way forward? There are 3 options for BBI. 1, we see the current process through, take it to the Court of Appeal and likely get to the Supreme Court. 2, through Article 256, a parliamentary initiative can be initiated, which focuses only on the amendments that can sail through Parliament and which don't require a referendum. The things which require a referendum are set out in Article 255. 3, we could use the same bill that was previously introduced as a popular initiative under Article 257 and instead introduce it under Article 256 as a parliamentary initiative and take it to a referendum. But through Article 255 to 257, the amendment process permits each generation to change the constitution in much the same terms as previous generations. The courts shouldn't complicate this or wait till there's this great upheaval to yield to the will of the people. If the goal is to create a consensus-based constitution, then compromise will be a political necessity with the voice of the whole, so that the voice of the whole can be heard. So with that, thank you for joining us on the Media Police Post. Columnists, people, we're putting you on notice.